Okay.
Welcome to the last in our series of Retake Zoominars. This one is focused on the Green Amendment. It was first introduced in 2021, and this year the Green Amendment has been introduced in both chambers as SJR 6 and HJR 4. As with any legislation that seeks to make industry play fair and abide by law and regulation, the Green Amendment is encountering misinformation and strong industry opposition. Tonight, we will find out what the Green Amendment is, what it isn't, and how it has been implemented in New York and Pennsylvania, and how it could benefit New Mexicans. I'm Paul Gibson, the co-founder of Retake Our Democracy, and
Hi, everyone. I'm Roxanne Barber, the other co-founder of Retake Our Democracy. Welcome tonight. Happy Groundhog Day. Let's get this right the first time, where we're going to have to repeat it over and over, right? I want to tell everyone that we did figure out closed captioning, so that is available. We had a Zoom last night, and what you need to do, it's available, and you will probably find it under More, and it says Captions, and then you click on that, and that's how you get it started. You got to enable it yourself because some people don't need it, and so they don't want to see the words going across their screen, but it is available to you. So for those of you who might be on tonight who don't know about Retake Our Democracy, I'll just say really quickly, we're an all-volunteer organization here in New Mexico. We're a 501c3 nonprofit. We support advocates across the state, and we primarily help people make their activism easier and more effective. We have a blog, we have a radio show on KSFR, and we send out legislative alerts during the legislative session. So I invite you to go to our website, and that's retakeourdemocracy.org. And welcome.
so we've assembled a panel of environmental justice advocates to flesh out the issues tonight. Our panel includes Maya Van Rossum. She's the founder of the Green Amendment for the Generations movement and author of the Green Amendment, a book outlining the case for why we need constitutional protection of our right to clean air, water, and land. I don't think we have to convince any of our attendees of that. Maya has been working with environmental justice activists to pass the Environmental Rights Act, aka Green Amendment, in New Mexico since 2020. Maya has also served for the last 30 years as the Delaware River Keeper, working on the front lines of environmental activism and litigation. Mark Freed is a Pennsylvania attorney who focuses on public sector law and environmental law and litigation. Freed has worked on the responsible and strategic implementation of Pennsylvania's Green Amendment in a number of cases and assisted in promoting the Green Amendment legislation across the country. He will speak about how the Green Amendment has been implemented in Pennsylvania and in other states. Todd Oman of New York is the managing attorney at the Pace Environmental Litigation Clinic and a professor of law at Elizabeth Haub School of Law. He closely studied and advocated for the passage of the New York's Green Amendment, which passed in 2021, and he now works with a team of environmental advocates and attorneys in New York to ensure the best implementation of New York's Green Amendment and to educate members of the public and government officials on their new rights and obligations. And Senator Antoinette Sedillo Lopez, our progressive stalwart and the Senate sponsor of this year's SJR 6. She will tell us what we can do to help get this joint resolution passed this year. And she is going to have to cut out right at 7 o'clock because she has a
Senate Conservation Committee
event.
Conservation Committee dinner that I'm, it started right now, but
Vice Chair.
be late there.
Well, God, we really appreciate you being here and being late for that dinner. I'm sorry about that. There's always some kind of conflict, right?
Roxanne, will you outline how we're going to do this tonight?
Right. So somebody had said something about not being able to see other participants. This is webinar format. It's different than a meeting format. So all the panelists, you're going to see the panelists. We can see each other. We can't see you. and you cannot speak, we can see your names listed as participants, so we know who's on. So the way this works is Paul and I are going to ask questions for the first hour, and then we're going to leave the last 30 minutes for participant questions. So what you need to do, we're not going to do raise hand. We're going to use the Q&A function, and the Q&A function should be available along your bottom menu bar.
Under more.
Right. It's either under more, or if your screen's larger, sometimes it pops up by itself. So please use the Q&A for your questions, but I want to suggest that you give it 30 minutes or so, or maybe even longer, because inevitably a lot of the questions will be answered in the first hour of the program. But then around 7 or so, we'll get to the Q&A and we'll answer your questions, but just keep in mind that the senator has to leave at 7, unfortunately. And you can also use the chat to chat amongst yourself. Because we're participating, we don't always, we're not going to be answering questions from the chat, but if any of the panelists see questions in the chat that you want to answer, and it's not your turn to talk, you have time to answer, go ahead and do that. Or if anybody else on the call has any knowledge and can answer the question, please feel free to do that.
In the chat.
Yeah, in the chat. But for your formal questions to the panel, use the Q&A. Okay, thanks everybody.
You got the first question.
Yeah, we're going to start with Maya. Maya, tell us what the Green Amendment is exactly, what it could do and what it won't do.
So if you wanted, I do have the language prepared to put up on share screen. But while we're working on that, I can just jump in. So what the New Mexico Green Amendment does is it adds to the Bill of Rights section of the New Mexico Constitution a right of the people to clean and healthy water, air, soils, and environment, a stable climate. Here, I'm going to get the language right up right now. So you can be looking at it while I am talking about.
It's a little small, so I don't know if anybody's going to.
I got to put it up. I got to put it up.
Let her do it.
Okay.
Yeah.
ahead.
So hopefully, this is just really what it does, right? It adds to the Bill of Rights section of the state constitution, the right of the people to a clean, safe, and healthy environment. And it also ensures and it makes clear that there's an obligation on all government officials to protect the natural resources of the state for both present and future generations. By having this Bill of Rights placement, what we are doing is we are ensuring that the environmental rights of the people are protected as powerfully as those other fundamental freedoms we hold dear, things like the right to free speech and freedom of religion, for example. And I'll just stop the share. The Bill of Rights section of the Constitution, that's where we recognize and protect those other fundamental rights. And so if we want to give our environmental rights that same powerful recognition and protection, we also need to place them in the Bill of Rights section of the Constitution. What the amendment does with this placement and with its language is it ensures that all government action, whether the legislators are regulating or legislating or the regulators are regulating, whoever in government is taking action, their actions and activities have to be informed and guided by their obligation to protect the environmental rights of the people and their obligation to protect the natural resources for present and future generations. And so what this really does is it really strengthens the existing laws that are already in existence in the state of New Mexico. It ensures that they are all environmental laws are interpreted and applied through this lens of protecting the environmental rights of the people. If there's a gap in the law, for example, with regards to PFAS, where an absence of legislation or regulation allowed the proliferation of those dangerous man-made family of chemicals to be utilized in ways that allowed them to get into the environment and really devastate drinking water supplies and people's health and their lives. Well, if there's a right to clean water, people could have turned to that constitutional right to seek and secure government action to address the problem sooner. For example, in the Commonwealth of Pennsylvania, we did that using Pennsylvania's Green Amendment, and we got the governor's office and the regulators to actually pass some of the strongest PFAS drinking water protections just this past year that it now exists in the nation, all by turning to that right to clean water. It also becomes a really powerful foundation for good government officials that want to take more protective actions to be able to turn to their constitutional obligation as a foundation for that better protection. Now, you'll notice I've mentioned a lot that government action, right? The Green Amendment applies to government action, just like all of the other Bill of Rights provisions do. So we're not going to see lawsuits between downstream neighbors and upstream farmers or industrial operators. This is all going to be focused on ensuring that our government officials are using their authority and power in ways that protect our environmental rights and our natural resources. It will apply to all levels of government, including the legislature, right, the governor's office, the regulatory agencies, even local government officials will now have an obligation to ensure that as they are exercising their power, they're doing it in a way that respects and protects environmental rights. And this can actually be very beneficial because it really can ensure that we are looking for this greater protection at every level of government. So, it's often at that local level when smaller modifications are necessary in order to protect the environment can take place in a way that's more cost effective and cost efficient. And then the only other thing I just want to emphasize is that, this is not going to result in people who bring an action against the government to get money damages. It's going to be about remedying the governmental behavior that's resulted in a problem or a constitutional violation, not a problem.
Okay, well, thank you.
Okay. There's a follow-up question for you. You mentioned that this year's version of the Green Amendment, since it's been introduced, I think, twice before now, right? Is that right? Yeah.
Yes.
Is explicitly lifts up underserved, underrepresented, and climate oppressed populations. So how exactly does it do that? And can you tell us how this latest version of the amendment is different and why those changes were made?
Yeah. So, the difference between the final provision from last year and this year is that it does now include language that the environmental rights of the people must be protected equitably for all people, regardless of race, ethnicity, tribal membership status, socioeconomic status, gender, or geography. And so what it really means is that we all have the same constitutional right to a clean, safe, and healthy environment. And if a community can demonstrate that government action continues to results in them being disproportionately impacted by water pollution, by air pollution, by the devastating consequences of environmental degradation, then there is the potential for a constitutional question there, right? Because we all have the same right, and government really now must ensure that they are undertaking best efforts to protect the environment and natural resources for all people equitably. We also did clarify at the end of the last session, we offered this additional clarity, or the legislators offered this additional clarity, that money damages could not be the result of a legal action if there is one. So if you felt that your environmental rights were being violated and you were successful, the result couldn't be a money payout from government to you. The result would be that whatever is causing that constitutional violation would have to be remedied. For example, if a series of regulations were passed that were demonstrated to result in violation of the constitutional rights of the people, or the obligation of the government to protect the natural resources for present and future generations, then the problematic language in those regulations would be declared unconstitutional, and therefore they would be unenforceable. Same thing with a law, same thing with a permit. And and what would then happen in response, those provisions would be unenforceable if the arm of government that was responsible for that action, again, the regulatory agencies, the legislature, wanted to continue to move forth with the original proposal, they'd have to modify it and find a way to move forth with it in a way that protects environmental rights while also accomplishing their goal. So it just remedies the problem for everybody. It's not about paying out money to individuals. So those are
Okay.
the two biggest differences.
Okay, thank you, Maya.
Yeah, I
Oh.
think we had a follow-up, but I think that's gonna get covered later. So I think we're gonna skip that for now and go to the senator.
Yes, welcome, Senator. Can you tell us why we need the Green Amendment here? And why are New Mexico residents unable to force government to enforce its law and regulations?
Well, one of the reasons we need it here, I mean, there are many reasons we need it here, but one reason that I've been talking a lot about today is how important it is to preserve the legacy, the environmental legacy of the regulations that have been passed in this administration. Some of you may remember that Governor Richardson had, after 8 years of painstaking rulemaking, that was really great climate regulations, great environmental regulations, saw that basically overturned within 10 months of the Martinez administration. And now what would happen if we have the Green Amendment is every attempt to overturn those regulations would require a review of the impact of overturning that regulation on air, land, water, healthy environment, which would mean those really great regulations on produced water, methane, clean cars would likely stay, because overturning them would be so bad for our air, land, and water. So that is one sort of concrete thing that we need it for in New Mexico.
Can
The
I
other
ask
reason-
something, Senator? Would it also make it possible, because it's no secret that we're not doing a great job of actually inspecting the produced water leaks or the methane releases? Could a suit force the Environment Department to start enforcing their own regulations?
Well, and that actually, thank you, because that was a nice segue into my second point, which is it would be the policy of the state, has the primary overarching policy of the state. And that all of the state would have to further that policy, including adequately funding the agencies to further that policy. And so whether there's a lawsuit or not, we would be swearing every time we swear to uphold the Constitution to pursue that policy, including the policy you mentioned about adequate enforcement.
Okay, thank you.
Okay, great. So this one is for Maya and Todd, but Maya, maybe we're going to go to New York now and talk about the Green Amendment there. So first, Maya, tell us a little bit about the process of getting the Green Amendment through the New York legislature and into the Constitution, and any sort of opposition that you faced and what the arguments were and how you overcame them. And then we'll go to Todd.
So the process in the state of New York that was pursued is pretty similar to New Mexico. It had to go through the New York legislature first, and then it would go before the people. Although it had to go through before the legislature twice in 2 consecutive legislative sessions. And just like in the state of New Mexico, what we really found were that there were communities on the ground who recognized the importance of having this additional protection at the constitutional level to guide all government action in the state. And they really rallied together to spread the message about the power and importance of recognizing environmental rights in the Constitution, right? We all value the right to free speech and freedom of religion, but we must have clean water and clean air and healthy soils in a stable climate, right? To have thriving, successful lives. So they got, the people came together just like they are in the state of New Mexico and advocated for this. We had powerful legislative champions who were willing to step forth and make the proposal. And when it ultimately went before the people, it passed by over 70% of the vote. It had bipartisan support in the legislature and in that public vote, which was really powerful, helpful, and important, and was a testament to this recognition that we all really do depend upon a healthy environment.
Okay, great. So Todd, I guess Green Amendment passed in New York about a year ago. Tell us what has happened so far? Has there been a lot of litigation? What kinds of litigation, and what were the results of that?
Sure. So yeah, it's been a little over a year, about 13 months since the amendment took effect. It was passed a little bit before that, but it took effect January 1st of last year. Statewide, I'm only aware of, and I think Maya's only aware of probably 6 cases that even raised the Green Amendment. So as far as whether there's been a flow or a massive litigations, the answer is no. We've had a handful of cases that have raised it. We haven't had any kind of final judgments. We have had one determination denying a motion to dismiss, which just doesn't mean the claim will ultimately be successful. It means that the petitioners there had the right to state the claim. And that was in a landfill case where our state environmental agency, which is called the Department of Environmental Conservation, DEC, where DEC had been trying for years to enforce against a landfill that had been not compliant with its permits, unsuccessfully trying to enforce, and was resulting in a lot of air pollution and odors and other issues. And the court there denied DEC's motion to dismiss the lawsuit, holding that the local residents who were affected by this failure to enforce could raise the Environmental Rights Amendment, the Green Amendment, as a basis for that claim, to say that their DEC's failure to enforce against this landfill, failure to remedy the situation, was resulting in a constitutional violation. So that's the only substantive decision so far in the courts. It's been raised in a number of contexts. We at the clinic have raised it, opposing a permit grants for a power plant. It ultimately did not become an issue because DEC denied that permit on other grounds. It's been raised a couple of times with no substantive decisions challenging either industrial development or other types of development where the local residents felt that approving that development would result in a constitutional violation. So it's been raised in a handful of cases. There's only been one real decision thus far.
Sorry, we were muted. I had to
Oh,
unmute.
sorry.
Go ahead, Paul.
Let's shift to Pennsylvania. Mark, welcome. I bet you were wondering if you're ever going to get to talk.
That's okay. I'm enjoying the conversation.
Okay, well, can you tell us a little bit about the experience you've had in Pennsylvania? You've had that for quite a while now.
Yeah, so there's a couple aspects to this. I know there's been a lot of focus on the litigation and whether or not it's going to result, whether or not an amendment's going to result in a lot of litigation. I think what we've seen is it really hasn't. I think we see about an average of, frankly, less than about 10 reported cases a year that even cite our Green Amendment. Most of the cases really don't turn on the Green Amendment. I think if you look at the cases, and I can tell you my own experiences, these cases are going to be brought in any event, and the Green Amendment's really added as an additional basis for the claim. And frankly, most of the cases don't, when they're decided, don't turn on the Green Amendment because, folks that are familiar with constitutional jurisprudence know that courts will generally try to avoid making a constitutional determination unless they need to, so they're going to go first to the statutory determination. I think the other important aspect and to look at things other than litigation is really what the constitutional amendment has done for government officials in a very positive way. And I will tell you, I'm also an elected township supervisor. I'm not sure what you call them out in New Mexico, but that's essentially part of our governing board in our municipalities. And I'm also a solicitor in a number of townships. And the environmental amendment really provides the opportunity, and that's a phrase I heard Maya use that I really like, so I'd like to keep using it. It really provides the opportunity for local government officials and state government officials to consider, take into account, and be empowered to take action when it comes to environmental issues. So I know we tend to focus on the litigation piece, but what we've seen is that there's been sort of a a general cultural mind shift in the way we think about things because we have the Environmental Rights Amendment.
Boy, would that be nice. Maya, you had a little something you wanted to add, I believe.
So I saw a comment in the chat that isn't it about litigation? And really it's not. It really is about avoiding litigation by getting our government officials to properly consider and protect the environment from the get-go. And as Mark said, that really has been an evolution that we've seen in the Commonwealth of Pennsylvania. And it's action and activity we see in Montana, where they've had the amendment for a number of years now. And what we find is that advocates use the Green Amendment, their language, and their entitlement to a clean, safe, and healthy environment in their advocacy. And because government officials, all government officials have an oath to uphold the Constitution, they really consider these environmental arguments much more seriously. And we find much better outcomes that help us avoid litigation and avoid the costs and expenses of environmental pollution and degradation before we even need to take that step. So that's really the goal, is better decisions, not litigation.
Yeah, litigation is just a tool to enforce it.
Okay, thank you. So a follow-up for you, Mark. Can you tell us, can you describe a couple of cases that are typical of Green Amendment litigation in Pennsylvania?
Sure. And I'm going to really talk about beginning in 2013. Just by another little bit of background, I also have been an assistant counsel with what we call the Pennsylvania Department of Environmental Protection. Was also an environmental crimes prosecutor in the, starting in the 1990s and going into the 2000s. And I can tell you from most of my tenure, the Environmental Rights Amendment, although it's been around for many years before that, was a right in name only. It was really not given much meaning based on court interpretations. And it really wasn't until the Delaware River Keepers 2013 Robinson Township decision that it really was resurrected and gained a new life, and really, and people started getting a much better appreciation for it. And so so the two main cases, the two big cases, which I think sort of show how it's been applied, are the Delaware River Keepers Robinson Township case and the case that we refer to as PEDF. And as a general as a general principle, the cases are generally enforced as a limitation on government power, as a limitation on government overreach. What we saw in Delaware River Keepers Robinson Township case was a situation where frankly, the state, in order to bolster up some of the oil and gas industry, had really essentially usurped the zoning authority of the local governments, and essentially attempted to create a statewide super zoning authority. And as we know, local government zoning is sort of the hallmark and core of the local government power. So the local governments essentially said, you're taking our power away. You're taking away our ability to really protect the rights of the individuals and our authority as a trustee to protect the natural resources. And the Supreme Court of Pennsylvania agreed and said, the local governments have this constitutional right, just the same as the state has a constitutional right. And it was not viewed as so much as empowering the local governments as limiting the state government from essentially stealing the power of the local governments away. So again, I know there tends to be a concern that it's going to be used as this, widely used as an ability of people to run rampant. What it really has done mostly in Pennsylvania is sort of keep governments in check from overstepping their authority. The same similar thing in what we call the PEDF case, which involved leasing on government property, on state property for oil and gas activity. And the question was, what can be done with the revenues from those leases? And because we have a trust provision in the Pennsylvania Constitution, which is the same as what's being proposed in New Mexico, the courts were able to say the state government as a trustee has to, using trust language, maintain and not waste the corpus of the trust. They had to, if this money is being derived from natural resources, essentially has to go back into protecting the natural resources. And so what it ultimately did was prevent the state government from squandering natural resources and the revenue generated from natural resources on things unrelated to the natural resources. So again, some of the big cases that we've seen really relate to keeping the governments in check and not overstepping their bounds in protecting the government. Now, outside of litigation, as we were saying, and this often turns into litigation or can turn into litigation when you're trying to protect those rights, is it's also empowered governments to make decisions, take into account environmental issues when they're making land use determinations, when they're making zoning determinations, when they're making all sorts of determinations. And when they're challenged on that, the constitutional amendment is an authority that they can point to say, we're authorized to do this by this constitutional amendment. So it's both, both acts as a limit on government power, but also authorizes and again gives the opportunity for government to consider environmental issues in the actions they take.
Okay, great. Let me just interject for a second. Since we know that Senator Cedillo Lopez has to leave at 7, I want to just tell everyone that if you have specific questions for her, go ahead and put them in the Q&A, but put, Senator at the beginning so we know that your question is specifically for her, and then we'll try to get those answered before she leaves if we need to just take a break and do that and then go back to the rest of our questions. So go ahead and do that, and then maybe about 10 minutes too or something we'll stop and see what questions you have for the senator. Did you have a follow-up for
I did.
okay. For Mark?
Mark, this is for you. Pennsylvania also has a significant rural population. Oh, I'm sorry. I skipped the, never mind. I got a different question for you. Follow up.
Okay.
Pennsylvania has been a leader in the production of oil and natural gas, as is New Mexico. One of the concerns raised in New Mexico is that the Green Amendment would kill the gas and oil industry. How has the Green Amendment impacted the industry in Pennsylvania?
So it's interesting. It's an interesting question. I think that the question almost answers itself. I think you're right. Pennsylvania is a leader in oil and gas development, both on the drilling side as well as the logistics conveyance pipeline side. I think the fact that it continues to be a leader in that area has shown that it really has not negatively impacted the industry. As I noted, what it's really done is made the government be conscious of the environmental issues, such as we mentioned in the PEDF matter. And it's interesting to note in the PEDF matter, the case didn't say you can't drill on public land and you can't remove oil and gas from public land. What it says is the revenues generated need to be used for the same things that they were generated from, which is the natural resources. So it's really much more of a balancing and limitation. And same with the Delaware River Keepers Robinson Township case. It didn't say that the governments can't take action. On the contrary, really, it said that governments have to stay within their lane. You can't use your desire to drill, to develop these resources to overstep what are your traditional governmental roles. So I think what we've seen really is that it really has not, in my opinion at least, and people from industry may have a different view.
Of course.
But I think the fact that the industry continues to thrive And frankly, it's affected, I think, more by economic factors than it is by any kind of environmental rights factors. It really has not had a negative impact.
So let me ask you this, one of the issues we have here in New Mexico is we have in the Permian Basin, we have methane flares just out of control. And we're not monitoring or,
Preventing.
fining them for
Yeah.
that. And it's in their lease that they're not supposed to do that. Would we be able to use the Green Amendment to force them to capture their methane?
So and again, not being a New Mexico lawyer, knowing all the facts there, it's a little hard for me to answer. I would hope if it's in a lease and is it a lease with the government entity?
Yeah, well, maybe,
I would hope that that the government entity, based on the lease itself, and perhaps with the Environmental Rights Amendment bolstering their authority, would actually enforce the rights that are part of the lease.
did you want to comment on that, Senator? Oh, you're
You're
muted.
Sorry, I muted myself when the janitor came in and started taking my trash and stuff. So, but I think it's very, very important to realize that it would put a duty on the state to enforce those agreements. And the loss, if we needed lawsuits, it would be to force the state to fund the resources necessary to actually enforce those agreements. Some of you are familiar with the Yazzie v. Martinez case. That just needs to happen. It is a crime that we have these leases and these good provisions and an inability to enforce them. They're not adequately funded. They're not adequately resourced. And this amendment would help push that.
Okay, so I have another follow-up for Mark.
It's my lucky day.
Yeah, happy day. We ignored you for a while. Pennsylvania also has a very significant rural population. Has the Green Amendment caused undue pressure on rural governments that may be under-resourced in responding to Green Amendment challenges? And have you had any litigation impacting rural communities?
So it's interesting. It's actually, I think, gone the other way, where the Green Amendments actually, I think, helped to support the local communities. As I mentioned in Delaware River Keepers Robinson Township case, really that was an effort to take away the authority and the decision-making authority of the local governments regarding what's allowed to take place in their municipalities, whether they want certain oil and gas activity, whether they don't want oil and gas activity or other types of activities. And what that case says is, no, this authority, this decision-making really resides with the local entity. As you mentioned, a lot of those local entities, the majority of those local entities are in rural areas. The other part of this, and I know I seem to be hitting one or two of the same themes, but they keep coming up, is that when it comes to rural areas, and what you find is in a lot of the rural areas, they are particularly tied into their natural resources. They're particularly aware of their natural resources. And what the environmental amendment has done is really allowed them, given them the authority, the basis on which to make determinations. I know a lot of folks, when you see resolutions, ordinances, different things like that, and there's a lot of whereas clauses, they tend to get ignored. But those whereas clauses are really where local and even state legislators are able to put the basis for their decision making. And a lot of those whereas clauses are relying on Article 1, Section 27, or as a basis, as one of the basis to take action and to support the action on which they're trying to protect the natural resources.
Okay, thank you for that.
Thank you, Mark. And what about in New York, Todd, rural communities? What's been the impact there?
So there hasn't been an impact yet. I mean, the landfill case that I mentioned briefly earlier is a relatively rural community, and the way the amendment has been utilized there is to give the residents of that community a voice in how the landfill is operated and a say in how the landfill is operated and how DEC enforces our environmental agency enforces against that landfill. I would say just on a looking forward basis, to add to something that Mark was talking about, but a slightly different angle on it. What I've seen in rural communities here in New York, we have a strong state environmental statute in New York that allows municipalities and planning boards to not just allows, but commands municipalities and planning boards and communities to look at the environmental impacts before you approve something like a site plan or a zoning change. New Mexico, to my understanding, does not have that same statutory protection. And this would give a tool to rural communities. If there was some industry coming in or some development coming in, they felt was very harmful to their community, but they didn't feel like they had a statutory authority to deny that development or to deny that site plan. The Green Amendment gives them that authority. It gives you a constitutional, not just a constitutional reason, but a constitutional obligation in some cases to not allow harmful development, to not allow your community to be exploited, where a rural community or a community without kind of the resources to fight a powerful developer may not otherwise have that in their toolbox. And so I would just, if I were representing smaller rural communities, I would say, look at this as something to help you preserve your community and to protect your
Great. Okay. We're going to go back to the senator, but did you have something to add to that, Maya? You've got a hand up there.
Yeah, so Todd and Mark really very powerfully spoke to the substantive sort of piece of the Green Amendment, but Todd did just allude to the procedural part of it as well. And that procedural part goes both ways. The thing to recognize is that compliance with existing legislation and regulations on the books does not necessarily mean compliance with the Constitution, right? The Constitution requires its own mindfulness and thought process. And so whomever the governing body is that's undertaking the activity, one of the things they have to do is do that independent constitutional analysis to ensure they're protecting the environmental rights and protecting the natural resources as they're obligated to do. When they do that analysis and they lay out clearly for the courts or for the public how they undertook that analysis and arrived at their conclusion, whatever their conclusion was, depending on, your position in the community, but whatever their conclusion is, the courts will tend to defer because that government entity fulfilled its obligation and demonstrated that they were mindful and careful about protecting the environmental right. They identified their compelling state interest if there was going to be an infringement. So just want to make clear that there is this also robust process piece of it, as Todd talked about being in the New York statute, and that really can help secure much better governing decisions, tweaks when necessary, but also it helps the court to assess whether or not the government entity fulfilled its constitutional obligation.
Okay, thank you. Okay, Senator, so we hear there are 20 sponsors for the amendment this year at this point.
And a couple of people just told me today that they hadn't had time to go to the office to sign off on it. Pamela Herndon, I hope she did it today, said that she was on her way.
Okay, that's great. And we know there are a few dozen organizations backing it too. But let's talk about, we all know that the gas and oil industry has a very big influence in the state. So what are you hearing from other colleagues? And your colleagues seem to be more receptive than they have been in the past?
Well, and I think as was discussed when we're talking about Pennsylvania, it's not going to stop the oil and gas industry. It's going to make it operate in a much cleaner, responsible way. That's the goal. That's what we want. And then I think the gas industry, in addition to costing us so much in health costs and the mess that were the financials of having to clean up the mess, the gas industry has also been up and down for our state like this. And we need to diversify our economy so that we're not, building up programs and then ending them and building up things and then firing people. It has not been the robust, healthy thing that we should do, that is rely on oil and gas for so much of our budget. And so that's something we need to be mindful of. And while there's nothing that the Green Amendment was going to do legally, but I think it will refocus everybody on what's truly important, and that is the future of our environment for our generation and subsequent generations.
So let me
Thank you.
ask you a follow-up, Antoinette. What are the most troubling obstacles we face in the legislature? And can you suggest the messaging that might move fence sitters?
Well, sometimes it feels, I was talking about this, sometimes it feels like whack-a-mole because, one false narrative comes up and then we have to respond to that. We spent a whole weekend responding to a Holland and Hart memo that was, well, this might happen in New Mexico, that might happen in New Mexico, even though none of those things have happened in any of the other states. And truly, I don't think our judges and lawyers are more stupid in our state and would allow that to happen. So that was annoying. And so that's one of the things I'm so grateful to you for having this this session, because people will have accurate information to respond to legislators who are repeating what the oil and gas lobbyists and under industries are concerned, because it might cost them money. And follow the money. I'll just obliquely say, follow the money.
Yep, we've said it before at Retake.
I have.
Roxanne?
Oh, okay. So let's go back to Mark and then we'll see where we're at. And I know somebody mentioned in the chat that you are actually answering some of those questions for you, Senator. So that's great. But if there's still some left, after Mark's done.
And I think I think it's getting to the time that I need to be focusing more on questions that you're going to ask me than.
Oh, okay,
and
well, maybe we
busy
can
on
just
it.
do that now, because we don't actually have more questions for you. So let's see what we've got in the Q&A, and then we'll go back to the other questions we have for the other panelists.
Great, thank you.
Sure. I looks like you've answered some of them. Let me see. Start with the first one. How would, oh, that actually is not for, okay, I'm sorry. I'm gotta follow my own rule here, which is to look for the ones that say senator. What is the stance from our governor, lieutenant governor, for the Green Amendment? This is Francis Gonzalez. Our copper extraction company is fighting the Green Amendment harder than last session. What's the plan to address that strategy?
The copper industry, it's interesting because the copper industry, I think, is going to be very important to a transition and a just transition. So again, I think it may be a false trope, and the copper industry needs to operate in a way that doesn't devastate the environment. And so it's unfortunate that you see the industry coming out so strong. Like I've been telling the industries that come to me, you know what, you shouldn't worry as long as you're doing the best you can do to protect our environment. But saying all of that, the lieutenant governor has been very helpful in giving me advice and has saying he thinks that, he's been wonderful and telling me a little bit about what's going on in Silver City and how, industry is just really concerned about this raising their costs or delaying their projects. And why. So he's been very, very helpful. Now, the official word I got from the government's office, and this is a few months ago, and I kind of just let it there, stay there, was that the governor generally doesn't concern herself with things that are not within her power and control. And since this amendment would go directly from the legislature to the voters of the state, she doesn't have a veto or power or the power to even sign it. It just goes directly to the people. And that was what the word I had gotten. Now there are all kinds of rumors flowing on all kinds of sides about this. So we wanted to have want to have a meeting with her, and then get her, because the word I got was from a staff member. And I really would like to hear from her, what she thinks, especially because this is so important to preserving her environmental legacy.
That's one way to frame it.
Yeah, thank
Well,
you.
Remember, look at the good things in the regulations. I mean, there are some really positive things that we really need to preserve.
Mhm. Be positive, Paul.
I'm being positive.
So we have a question from Aline Gush. She says, Senator, I'm feeling concerned and discouraged about exactly how to push back on the DIMS, especially with the executive branch pushing the hydrogen thing so hard. Defeating 4 bills for that last year didn't get rid of it. So I don't know what we can do next. If you have any ideas for concrete actions to take, please give us some suggestions. I'm feeling more powerless than in the past, and feeling powerless doesn't help.
Well, don't feel powerful. Empower yourself. Make those calls, have those conversations with your legislators, call the governor's office and get your voice out there. It's going to be the people that make this happen. That is your voices out there. You are all voters, and get your legislator not only to commit to vote for it, but have them co-sign. Tell them, hey, you co-sign and I'll stop bugging you. And so really just push and keep pushing. People who know me know that I'm nothing if not persistent. And Gail was telling me it took Representative Chasey said it took her 10 years to pass the ban on capital punishment in the state. And this is a very Catholic state. Think about that. And so I'm going to keep pushing and pushing until it happens. And you are going to make it happen. Activists, you can do it. So don't feel disempowered. We're just continuing to, whack-a-mole is a game, and we can do it.
We can play that game.
We can play that game.
So one more question for you, Senator, and this is from Muriel Carpenter. What can we expect this session respecting the timing of the Green Amendment getting through the various committees and onto the floor of both houses?
Well, it's not too late. If we get a hearing in the next week or two, it is definitely not too late. Bills are still getting introduced. And so it's concerning that we didn't get it right away, but in the Senate, they haven't dealt with one constitutional amendment yet. And there's some really important ones there to look at. So just keep pushing. One of the issues is it feels like they're playing a game of chicken, which chamber is going to go first. And I was told maybe we shouldn't have filed in both places, which has been a good strategy in the past. In the past, we went with whichever chamber had the first hearing, right? So in the Senate, the first year, we got a hearing the first week. Then in the House, we got the first hearing. And now there's this funny game of chicken. We're going to go with the chamber who gives us the first hearing. And so I think that it's really important to contact the chair of Rules Committee, which is Senator Duhigg, or the chair of, I forget the name of that committee. I think they changed it. The Environmental Committee in the House, which is Matt McQueen, and ask for a hearing. Maybe we should have a press conference. Let's hear this amendment and get that message out, because we're going to go in the chamber that gives us the first hearing. So if it's the Senate, we'll go through the Senate. If it's the House, we'll go through the House.
And no hearings have been scheduled yet.
No hearings have been scheduled.
Yeah,
And so, when you hear Matt McQueen saying, I'm not sure you have the votes, it's like, well, that process is a process. You don't always have the votes the very first day. There's a whole process of argument and lobbying that happens. So, just say, we're working on getting those votes, get the hearing in place.
Sponsor.
Sponsor the bill, yeah.
Sponsor the bill.
Thank you so much. I'm pretty sure we got all the questions that were directed to you, and I know you need to go. You're already missing the first hour of the dinner. So thank you so much for being here, Senator. We really appreciate it.
And thank you so much for organizing this panel. Thank you, panelists. I appreciate you so much. And I love hearing these wonderful stories from other states. Thanks. Bye-bye.
Bye-bye.
Thanks. Okay, let's get back. We have a couple more questions for the panelists, and then we'll get to the rest of our participant questions.
I just want to make one comment. I should have made it while she was on, is we are very lucky to have her.
Yeah, she's been great. So this is for both of you, Mark and Todd. And Todd, I know the Green Amendment hasn't been around as long in your state, so that you may not have an example, but a lot of what we hear here in New Mexico is, oh, there's going to be all these frivolous lawsuits. So what do you say to that, Mark or Todd, or both of you, whoever wants to go first?
Well, I mean, I'll take it first. I think I actually addressed this somewhat already. I just don't think we've seen that. I don't know. I mean, I know everyone's got fears. I have a lot of fears when I walk out of my house in the morning, but I don't know there's any evidence for that. As I mentioned before, I think we're seeing less than 10 on average reported cases a year, even citing the Environmental Rights Amendment. Very few cases are even turning on the Environmental Rights Amendment. Most the focus of the cases that have gotten traction in the courts have really been about limitation on government power, not expansion of government power. And as I mentioned, just general legal jurisprudence is you're not going to rely on a constitutional provision when you have a legal provision there. I think what we have seen, and again, as I mentioned before, is that what this has really done as far as empowering is empower legislators to, as Maya said, go through the process, but also substantively make decisions, pass ordinances, pass laws that protect the environment.
So I can add a little bit to that. You're right, we don't have the same experience. I mean, I mentioned before, we've only had a handful in over a year of having the amendment in place, which is some piece of evidence. I'll add anecdotally that I have a colleague at Pace Law School who has studied this internationally, and the same is true internationally. There's been a lot of countries have a constitutional right to clean environment in varying forms. And he has looked at litigation across the world, and it's been spare. There's not been a lot, and very few cases, as Marcus said, very few cases, even if it's raised, does the case turn on that. So it's not adding a litigation burden is another way to look at that. And then let me just add one more conceptual piece for the non-lawyers, which cannot be repeated enough. This is a constitutional provision. And the Constitution protects the people from infringement by the government. It does not give you any rights against private entities. And so you're not talking about a new tort where you can sue any company because you perceive they have hurt your environment. That's not how it works. You can't have the flood of litigation that is envisioned in some of the opposition simply because it's only going to come into play where there's an intersection of government action and citizens' rights. It's not about corporations. It's not about industry. It's not about lawsuits suing to get money, and especially in New Mexico where it's expressly forbidden. But it would be essentially forbidden anyway because it's a constitutional protection. It's not a tort. It's not another claim that can be brought willy-nilly. It's limited in its application. And so there are reasons why you don't have floods of litigation.
And I just want to round it out. As people know, the other state that has a green amendment is the state of Montana. And similarly, in Montana, we see about a handful of cases that make it to the courts a year. And I am aware of 0 cases that ever have been dismissed as being frivolous. So the experience across green amendment states is all on par with one another, and none of it supports the false accusation that this is going to result in a flood of litigation that in and of itself is going to bankrupt and overwhelm New Mexico's government. That's simply not the experience anywhere else. We wouldn't anticipate that here. The lawyers in New Mexico are just as ethical as everywhere else, and the judges are just as capable of interpreting and applying a constitutional environmental rights amendment as the justices in Pennsylvania, New York, and Montana.
And actually, Paul and Roxanne, hopefully this isn't too in the weeds, but we've talked about this Holland memo. And there's one central problem with it, which kind of reveals it to be a little bit of a false flag kind of thing. There's this idea that fossil fuel or traditional energy companies are going to litigate against clean energy using the Green Amendment. And as someone who's litigated for 20 years, who represented the industry for 10 years of that in the beginning for a big New York firm, it's not possible that would happen. Fossil fuel traditional energy has every impulse and every interest in keeping the interpretation of the Green Amendment narrow. So the fact that they would come under some false lawsuit seeking an expansive definition to stop development of solar is absurd. They are so much better served not doing that than by doing it, because they probably won't win that type of lawsuit. And if they do win, they're only hurting themselves in the big picture. So this idea that that's going to be the result is a little bit ludicrous. It's to me, it strikes me as a total red herring and not something that could ever really come into play.
What was just an interesting, I'm sorry, go ahead, Maya.
Yeah, I was just going to say, I just want to identify 3 aspects of the proposed New Mexico Green Amendment that clearly identify it as a powerful, positive tool for helping to advance well-sited, well-constructed, well-operated, truly clean and renewable energy operations. 1, the amendment explicitly recognizes the right of the people to a stable climate. That in and of itself, advances, it means is a powerful way to advance non-fossil fuel options, right? Non-climate releasing, climate change emission options. It requires the protection of the natural resources for present and future generations. We all know that while the climate crisis is having devastating consequences today, it is an existential threat to future generations. And so that obligation on New Mexico government officials to protect the natural resources of the state in a way that will, in the long term, protect future generations is a powerful positive for supporting clean and renewable government decisions that advance clean and renewable energy projects. And then the other thing is it's one of the standard principles of constitutional sort of law and interpretation is that if there is a belief, if there is a determination by the courts that some government action might result in an infringement on a constitutional right, then the government is still allowed to advance that action or activity if they can demonstrate it's in support of a compelling state interest, which avoiding the climate crisis and not exacerbating it certainly is, and that the action that they're taking will serve that compelling state interest, and the government has done everything they can to minimize the level of infringement on the right. In this context, it would mean minimizing pollution and degradation. And so the idea is that you would be advancing government decisions and actions that advance good, defensible, well-planned, well-placed, well-constructed, well-operated, clean and renewable energy projects, which is what we the people want, we the people need, and what the clean energy industry commits to doing. So for them, it should be a positive. And I'm sorry, Mark, in case I took some of your, because.
No, I mean, one of the things that they tell you very on in law school is that anyone could sue anyone for anything, right? But the real question is, how far does the case get? I mean, it's fine to say, oh, this person used this law to bring this case. But in reality, as Maya said, the judges are capable. They're going to see the case for what it is, and it's probably going to be dispensed with very quickly. So it's not so much about what someone may allege in one case. It's whether or not the case goes anywhere. And I think the experience is that these, to the extent there are frivolous claims, they don't tend to go very far.
Okay,
And remember, there have been no frivolous lawsuits under Green Amendments in any of the 3 Green Amendment states. So don't misinterpret what Mark
Well, that's
just
right.
said.
That's right. I was talking in generalities.
Exactly.
Okay, well, since it's 7:05, I think we should go ahead and go back to the Q&A from our participants to try to answer as many of those as we can. I know we've answered a few and some of them are just comments. So I'm just going to start with the first one, and we'll try to get through them, everybody. And I apologize in advance if we don't get to your question. And if we feel that it may have already been answered since you asked it, we may wind up skipping it. Okay, so Tyler Taylor, how would quote unquote clean air, clean water, et cetera, get defined? There are innumerable levels of pollutants that could be where the lines are drawn. Could any law or regulation get challenged as being good but not good enough, with some contentious people agreeing and others disagreeing?
I just answered a similar question in the chat side, so the double chat is a little bit confusing. So to answer it from a litigator's perspective, every single constitutional right you have has the same question. What's an infringement of free speech? What's an infringement of the free exercise of religion? What's an unreasonable search? And in every single one of those contexts, it's going to be up to the court to decide that in a given case based on the facts. And so that is not unusual. And to have some ambiguity or uncertainty as to where that's going to end up, that's part of having a constitution, and that's part of having a Bill of Rights that is written in a way that can be generally applicable and can be interpreted so as to serve the right it's trying to protect. You can't make a 25-page long amendment to try and cover every possible circumstance. It's just by its nature, a constitutional protection has to be interpreted ultimately by the court, and you will have some disagreement, and that will all come to pass and be fleshed out, just like all of your other constitutional rights have been. So that's not an argument against it. It's just a statement of how the Constitution functions and how these types of rights have to be applied and interpreted.
Yeah, and
Go
to
ahead.
follow up on that, I was often mused myself if we were to try and pass a 14th Amendment today, or a due process clause, or an equal protection clause, or even Bill of Rights, what does cruel and unusual punishment mean? If we held it to the standard of, well, we don't know what it means, we can't pass it, we wouldn't have a Bill of Rights. I think what Todd said is entirely correct. I will tell you that in Pennsylvania, the courts really have not had trouble interpreting these words. I think one of the more interesting ones, and there is a lot about there's case law on clean, safe, different things like that. In the constitutional context also. In the constitutional context, one of the very interesting discussions is, what does it mean to be a trustee? And there's a long discussion, and again, the court had this is at the highest levels. The Supreme Court had no problem determining what it meant to be a trustee in the context of the constitutional amendment. So I think Todd's right. The case law is going to develop over time, but that's part of the constitutional process.
And just for some additional clarity, so the way the law works, right, the Constitution provides the overarching guidance to all government action and activity. And then in the first instance, the way these things get interpreted is legislators legislate. They pass laws with an eye towards ensuring that they are protecting the rights and fulfilling their constitutional obligation. Those laws are also broad, but less broad. So then the regulatory agencies pass regulations that give additional definition in different contexts to those laws, and then permits and permitting and local decision making provides even further refinement on that site by site basis. And so it really is, and the courts only get involved when there is a concern that the actual implementation is going to result in a violation. And that's when the courts get involved. And if the courts determine there's been a constitutional violation, then again, they will identify it and they sort of kick it back to that other branch of government to remedy the violation. That's how our system of law works, with all layers having involvement. That's how it will work with defining what clean water means, what healthy soil means, et cetera.
And I'll tell you, in preparing for tonight, I did take a look, and I did do some searching through the New Mexico statutes, and there's that. It was very interesting to me because there's some of the very same phrases that are used in the proposed amendment in existing law in other contexts, and obviously the courts have had no problem, and the General Assembly had no problem passing the laws, and the courts have had no problem interpreting those laws.
Good to know. Thank you. Okay, here, do you want to read any of the questions?
No, 'cause
Paul?
I got my glasses. I can't
Oh.
read it.
Sorry. Sarah Manning is asking, in New Mexico, taxes on the oil and gas production goes into a fund which contributes to the state's general budget. How would the state's ability to use these funds be affected by the amendment? Will it be?
Can I just step in before we go to it? So, the very important case that Mark talked about in terms of the misappropriation of natural resources funds. One has to remember that all of these cases are in a legal context. So in the Commonwealth of Pennsylvania, the way there was this legal construct, the way trustee laws worked and other things worked, that is why when the Constitution was brought to bear on the process, it was determined that the co-opting of the money for the general operating budget was a misappropriation of those funds. Exactly how that would work out in the state of New Mexico, I don't think that we could imagine yet tonight. That's all going to have to be looked in the context of New Mexico, existing New Mexico law. So I don't know if anybody else wants to speak further to that, but I think we know there are a lot of hypotheticals and we do our best to offer information, but we can't actually determine the final outcome for everything without some really careful analysis.
I think that's right. And I think the other aspect to that is going to be very fact specific. And there were some very significant facts in the Pennsylvania case regarding where the drilling was taking place, how the money was being used. In fact, it went up and down from the Supreme Court twice because there were a lot of questions that went up. It went through the trial court, went through the intermediate appeal, went to the Supreme Court. Supreme Court made some rulings and said, but we need more facts. It went back down, it went back up, it went back up. So it can be very fact specific.
Yeah, thank
Okay.
you.
Okay, I'm just gonna ask this question. I'm not sure how it relates, but Willie Orr is asking, is there a copy of the Holland Hart memo and
So-
rebuttal available?
Yeah, so the rebuttal is up on www.nmgreenamendment.org. There's an executive summary and a secondary rebuttal actually written by Mark. The first rebuttal was written by a team of attorneys. Then there's the executive summary, and then there's a second rebuttal. Those two additional pieces will probably be going up on the website tomorrow. I don't believe in utilizing my platform to give voice to false information and misrepresentations, and that's what the Holland and Hart memo is. So if somebody would like to ask me for it personally, I'll put my email in the chat, but I'm not inclined to put that on a public platform because it's simply bad information.
Okay.
Okay.
Barbara Califf is asking, in the New Mexico Supreme Court, like the Pennsylvania Supreme Court, they said that the revenue from natural gas extraction must be spent on natural resources. Or I guess if they said, what would that do to our land grant permanent fund and our schools?
I think they answered that sort of.
Yeah, I mean, I think it's going to be the same kind of thing. I think there's a lot of detail here that we wouldn't have at our fingertips. Any good lawyer would spend a lot of time and attention on that. But I think, suffice it to say is that the Green Amendment is not going to shut down the oil and gas industry in the state of New Mexico, whatever it is anybody feels about that. But it is about helping to ensure that the government ensures that the industry operates in a way that protects environmental rights and their constitutional duty to future generations.
And just to be clear, that the Pennsylvania case that we were talking about had to do with drilling and extraction on very specific public lands and how the money was being used in very specific ways. And the court really went to a lot of effort to say it was okay to use it this way, it was not okay to use it this way. So it was not a black and white, oh, you can't drill or you can't use money or you can't do this. It was a very complex analysis that they did.
Okay, thank you. I have a question, and I just want to let attendees know that if you're not really asking a question in the Q&A, you're just commenting, I'm skipping that because we really want to use this for questions to the panelists. So I have an anonymous attendee who's asking, how is the Green Amendment different from Section 21 of our current Constitution? And Section 21, I won't read the whole thing, but that's about pollution control The legislature shall provide for control of pollution, control of despoilment of the air, water, and other natural resources, consistent with the use and development of these resources for the maximum benefit of the people.
Yeah, I'm just going to take that on because I've done a lot of analysis and spoken to this a lot. Article 20, Section 21. First off, it's in the miscellaneous section of the Constitution. Second off, it does not recognize a right of the people to a clean, safe, and healthy environment. And because it's not in the Bill of Rights placement, some of those really quality guidelines that come for interpreting the language that you have in the Bill of Rights, like there having to be a compelling state interest, that doesn't necessarily apply to different other sections of the Constitution. So Bill of Rights placement is much more valuable in terms of recognition and protection of a right. As Roxanne said, the focus of Article 20, Section 21 is on, it requires the legislature to control pollution and control despoilment of the environment. And ultimately, it gives the power to the legislature to undertake the work, specifically to the state legislature, to undertake the work of protecting the environment. And so if the legislature, as long as they're passing laws and working towards this control of pollution and control of despoilment, as long as they're doing that body of work, they've actually fulfilled their constitutional obligation, even if they're doing it poorly, even if, you know, communities of color and indigenous communities are being disproportionately impacted and find themselves in environmental sacrifice zones, even if you're drinking, you know, contaminated water that's giving you cancer or breathing polluted air that's causing a heart attack or an asthma attack, they're actually fulfilling their constitutional obligation. We, the people, you, the people of New Mexico may be no better off, but the constitutional mandate has been fulfilled. This interpretation has actually been confirmed by a court decision. It's the Sanders-Reed case, where the court confirmed this interpretation. And what the court said very clearly is your remedy, therefore, is elect better people to office, right? Your remedy is literally at the ballot box, because the constitutional obligation is for legislators to legislate. As long as they do it, even if they do it badly, your constitutional entitlement has been fulfilled, their obligation is fulfilled, but we may not be better off in terms of environmental protection. So elect different people to office.
So then
Okay.
you're saying that you're talking about that section 20 or 21, right? And
That's
so,
Article 20, Section 21, and that's why the proposed Green Amendment seeks to repeal that provision so that it cannot actually be used to misinterpret and weaken the new Bill of Rights language that is being proposed and hopefully will be passed, because that is inevitably what would happen. So we want clarity. We are creating this right of the people and obligation of government officials that is at that highest constitutional standing and should not be undermined by this existing provision that's about pollution control and empowers the legislature versus all levels of government to have primary authority over that body of work.
okay,
Okay,
thank you.
this is a comment, Nodia Brent, I'm assuming it's Brent Nodia, but he's saying he's for the Green Amendment, but he's concerned that it will remain mostly symbolic in states like ours that haven't had the will to expedite a just transition. Do you have any comment on that, Maya, or?
I mean, I don't know, you know, there are so many people here in the state of New Mexico that care deeply about the environment in the legislature and without. And when you create a constitutional obligation to respect and protect environmental rights equitably for all communities and natural resources for present and future generations, it is not something that can be lightly disregarded by government officials. And when it is, that is when the people, because the people have taken their power back in seeking and securing the passage of this amendment, that is when the people can then turn to the courts and try to have this more level playing field to be heard about their concerns. I will tell you, in the Delaware Riverkeepers Robinson Township case that Mark talked about, the Supreme Court that rendered that decision and the Chief Justice that actually wrote that decision was a very conservative Supreme Court. That Chief Justice was recognized as one of the most conservative jurists that you can find. But because we are using traditional conservative principles of constitutional law to recognize and protect the environment, the justices recognized that they were obligated to protect and respect environmental rights and interpret environmental rights in the same way we respect, protect, and interpret those other fundamental freedoms, that they were in fact obliged to render the decision and the determinations that they did. And the kinds of findings that we saw in that case and we see in other Pennsylvania case are the same kinds of findings we see in New York and we see in Montana. And I would not expect that we are going to have unscrupulous everybody in New Mexico ignoring this fundamental right of the people. I believe it will definitely make a difference. It is not something to be disregarded once secured.
Paul and Roxanne, I don't want to step on your toes, but I did see one question that I hope we can get to, which is this argument that somehow this amendment takes power away from the legislature and gives the legislative authority to the courts. And I know, Todd, you've delved into this in some of the comments. Is that all right if I address that?
No, that's a good question.
Yeah, go right ahead.
So I have to say I see it differently. I don't believe that the amendment takes away the right of the legislature. I think, like in any law that you have, the legislature is setting a policy. They're making a statement. Sometimes it's in detail, sometimes it's in less detail, but they're setting the policy, and then it's up to the courts who have the responsibility to interpret what that means, not based on their own personal policy whims, but based on well-established principles of statutory construction. That's the way it works in Pennsylvania. That's the way I would imagine it's going to work in New Mexico, where the legislature would, assuming this passes, would pass through, both houses, go to a plebiscite, and it would have to be passed by the people. And then it would be up to the courts to interpret. It's going to be self-effectuating. So it's in and of itself, it's going to have some power, but the legislature is also going to maintain a certain amount of power when they have subsequent legislation that they may use to implement it, that local governments may use to implement it. So I don't see it as a giving up of power. I think it's more in line with the traditional way that laws are made and frankly the Constitution has operated.
Okay,
Thank you.
great. I'm just, since we have a few more minutes, I'm going back to some of the more statements, not questions. And Glenn and Sandra Griffin said, one of the problems here in Southwest New Mexico is that so many elected officials are in the back pocket of extractive industries. I mean, we hear about how much in campaign donations that our legislators get from the oil and gas industry. So do you think that's going to be tough to overcome, Maya?
Well, I don't think it's unique to New Mexico. We certainly faced that in the Commonwealth of Pennsylvania when the amendment was first passed in the early 70s and when we secured our powerful decision in December of 2013. And since then, as they, that seminal case, that the Delaware Riverkeepers Robinson Township case that Mark refers to was about an excruciatingly pro-fracking law that the state legislature had passed that put in place automatic waivers from environmental protection standards for the industry. And as Mark said, usurped, preempted all local zoning authority with regards to that industry, but not others. So, and it's because we had this constitutional entitlement that we were, able to make a difference. But I do believe this really does come down to the people. The Constitution is fundamentally the people's document. This is our document telling government, you can govern over us, but when you do, here are the rules of the road. And now we are adding to the rules of the road that we have an inalienable right to a clean, safe, and healthy environment that you must respect and protect. And I think it's important, and I understand, that these that the levers of power, that industry has much more access to the levers of power, but we do need to remind our legislators here in New Mexico, like everywhere, that we are not asking them to amend the Constitution. That is not what they are doing if they pass the Green Amendment by majority vote through both houses. What they are doing is making a decision to let the people decide whether the people want to amend the people's constitution to include environmental rights. And I think we need to remind them of that. We need to remember that ourselves.
Okay, thank you. I think we can take one more question before we wrap up. This is from anonymous attendee. Are there examples of how the Green Amendment in other states, I mean, maybe New York, Pennsylvania, but maybe there's others that you might know about, Maya, where it has where it passed, where it has reduced or eliminated environmental injustices specifically against indigenous people on tribal lands?
So we only have 3 Green Amendment states, but we do have 3 Green Amendment states, Pennsylvania, Montana, and New York. All of them are very young and in the initial stages. And that's one of the reasons why we're still seeing the law evolve and develop, right? When we pass the amendment, not everything just instantly transforms. We have to get the amendment and then use the amendment through our advocacy and when necessary through our litigation. So I am not aware of a specific decision as of yet in any of the 3 states that specifically talk about indigenous lands. I am aware of cases, where we are talking about remote natural systems. But I think that there is a focused effort now on securing the many environmental justice benefits that Green Amendments provide. And I do believe that the successful New York case, the East Side community, was a community that is of lower income and burdened. I know in the Commonwealth of Pennsylvania, where the Green Amendment secured cleanup of a long ignored toxic site that was neighboring a low income community. But so the answer is a yes and a no, but a no with regards to indigenous lands in that specific way.
Yeah, it makes me wonder, would federal law override state law if it's on, reservation on federal BLM?
So, yeah, what we have to remember is that the state constitution applies to state government and state government action. So that is where it's going to have an effect here in New Mexico. We ultimately, our Green Amendment movement is ultimately to also get a federal Green Amendment, because that's how we're going to hold the federal government accountable. Both levels of government have a tremendous amount of power in a lot of contexts. That's why we need a Green Amendment at both levels of government.
Okay, well, thank you so much. I think Paul's has a few things to say to wrap it up. We really appreciate all of you being here, Mark, Todd, Maya, and to Senator Cedillo Lopez, and to all the attendees. So go ahead, Paul.
So I think what I'd like to close with is we've heard about a really good public policy that could help us in the long term to ensure that our state operates in the best interests of our environment and our health. And I think one of the things that I've taken from this is that one of the more powerful aspects of it isn't just for litigation, it's for sort of setting the moral compass for what the state is going to prioritize. And that if they're going to honor the Constitution, this constitutional right, they have to do some things. And it's not just letting, gas and oil run rampant and let methane flow freely. And so I think this is something that is different from just passing laws that can be easily removed or amended into something that can't do anything. And what I want to encourage all of you who are on to do, and we will be talking about this in a blog this week or next week, is that we need to get the word to the legislators. And so we'll have this video recording of this discussion up by 10 o'clock in the morning tomorrow on our website. And it just takes hours to upload.
Mm-hmm.
But once that's there, we're hoping that you will start using this video and sending it to legislators and saying you want them to look at it and talk to you about it. It's important whenever you give something to a legislator because you want them to absorb some thinking you're giving them, I think it's a very good idea to end your note to them with, I'm looking forward to talking to you about this. And so we're going, we have to do this. It's not going to pass if we don't really bend some arms. And so let's bend some arms together. And thank you, Maya and Todd and Mark, very much for being here. And to all of you out there, stay active. It's the only way we fix this mess.
Thanks, everybody. Oh, one last word. If you want to join we have weekly legislative huddles on Wednesday evenings from 6 to 7. Just go to our website, retakeourdemocracy.org, go to actions and events. If you want to join the huddle, we talk about all kinds of legislation that we're supporting. We update you on what's going on with the bills, and we ask you to bring what you know to the conversation as well. So 6 to 7 Wednesday evenings. I hope you can join us.
Okay, folks, it's dinner time.
It is. Well, way past their dinner in New York and Pennsylvania.
Bedtime.
Okay, thank you so much,
Thank you.
everybody.
Bye-bye.
Take care.